Hey everyone, this is Ben from Cut Law. Today we are going to talk about the legal concept of quantum meruit. Quantum meruit is a Latin phrase which simply means what one has earned. In the context of contract law, it means something along the lines of reasonable value of services provided. Many quantum meruit claims are made on express or implied terms of a contract, although some of them can be quasi-contractual. Justice Judith Prakash in the High Court case of Rabia B. Binte Muhammad Ibrahim and Saleh Ibrahim laid down two types of quantum meruit claims. One, the first is the contractual quantum meruit claim, which arises because there's a contract, but something happened during the term of the contract, and the contract was not completed, so the party who did work should be compensated for it. And the other type is a restitutionary quantum meruit claim. Restitutionary means to pay back. Where there is an express or an implied contract, but the contract is silent on the payment for work or services done, or where the contract states that payment will be made, okay, but does not fix the amount, then the quantum meruit claim will be a contractual quantum meruit claim. The basis of quantum meruit is to correct unjust enrichment of the defendant, the person being sued, because services have already been provided, work has already been done, so he's unjustly enriched. So it is restitutionary in nature to compensate the person. How do quantum meruit claims come about? Well, the first one will be contracts discharged by breach. For example, if I enter into a contract with person A to provide legal services for 1 year, okay, and then I start providing legal services, but in breach of the terms of the contract, party A did not pay me, okay? So because he did not pay me, which is payment is a condition of the contract, let's say I provided legal services work for 2 months. The contract term is 1 year, okay, but 2 months he still hasn't paid me. So I exercise my right to terminate. Then because the legal services may have not been provided fully, for example, it could be a merger and acquisition deal, or a capital markets, a debt transaction, which actually takes months or even up to a year to complete. But because I've already performed some of the work, I can sue the party A for quantum meruit, compensation for a reasonable amount for the services that I provide, because A cannot deny that he has received a benefit from the services that I have provided. Another basis for claiming quantum meruit would be contracts that have been discharged by frustration. A frustrated contract is a contract that after it has been entered into and without fault of either party to the contract, the contract is incapable of being performed, okay, because of an unforeseen or because of an unforeseen event, resulting in the obligations of the parties under the contract being very different from that contemplated at the time of signing. So it's something like an intervening event which makes it impossible for the parties to perform their obligations under the contract. Under such circumstances, if services have already been provided or work has already been done, but halfway before completion of the contract, but suddenly the contract has been frustrated, something happened to prevent the contract from being continued. So the party who has provided the work or services can make a restitutionary claim under quantum meruit for the services already provided. In fact, Section 2 of the Frustrated Contracts Act allows you to recover benefits conferred on the other party. The last basis for quantum Meruit claims would be void, voidable or unenforceable contracts. If a contract turns out to be unenforceable or void, then if services or work has been provided, then it's only fair that the person gets compensated for the work. Examples of unenforceable contracts are, for example, when a director of a company enters into a contract on behalf of the company when he has no authority to do so, and then the other party has already started providing services or work, and then it was subsequently discovered that this contract is unenforceable because there was no capacity. The director could not contract on behalf of the company. Another example for void contracts would be contracts that are set aside on the ground of misrepresentation. That means someone made false statements to induce someone to enter into a contract. Because under the doctrine of misrepresentation, the contract is void ab initio, that means from the beginning. So if services or work has already been provided and it is found that the contract is void because of misrepresentation, there is still a basis to claim for reasonable value for the work that has already been done under the contract. So that's all I have to say about quantum Meruit. Thanks for watching this video.